The Me Too movement, it has shed a lot of light when it comes to sexual abuse and harassment, but something that hasn't gotten a lot of attention is the statute of limitations for sexual crimes against children. Right now, New York has among the most restrictive statutes. Most victims, they're barred from filing once they turn 23. Now, there is legislation pending in Albany that would raise the ages for both civil and criminal cases. Now, my next guests, they're here to explain why it's so important. Elizabeth Cronin, she director of the New York State Office of Victim Services, and Tom Andriola, an abuse survivor. I recently sat down with both of them. Thank you both. I appreciate it. I want to get into the legislation in a second, the importance of it, why it's being held up and its chances. But Tom, you had unbelievable courage in coming forward, both to the courts and then publicly talking, as other victims have, about your situation. And in many ways, if anyone had any reservations as to why this legislation's needed, you're Exhibit A. So give the public a background. I guess start when you're 11 years old. Sure.
You know, when I was abused at 11 years old, I had been in a household that was relatively chaotic because I was adopted as a young infant. I had two older brothers who were adopted that were older than I was, ages 2 and 4. And so the chaos that ensued had sort of set the stage over the years, the grooming that had gone on by my older brother. My middle brother acted out a lot, and my older brother had sort of served to be, I guess, my protector in a way. And that led to this abuse on multiple occasions when I was 11 years old. I had no idea what was going on. I had no concept of what was happening at all. And so, you know, it occurred. It did not go on for a very long time, but it did happen on multiple occasions. And then I buried it. And I, you know, went through school. I did act out quite often in school. Didn't really understand why, and went all the way through high school and college with it buried. And you know,
you guys were at a conference this week where a lot of powerful stories were shared.
Yes.
And also, Elizabeth looked at the research. It's not uncommon for people to not only bury things, but also not to introduce when there's abuse going on with either a family member or a close relative or a close family friend, because I'd imagine there's concern about upsetting the environment. I mean, that common line, I'm gonna, if anybody ever touches him, I kill him or whatever, you know, that's a lot to put on the shoulders of a kid.
Absolutely, and it's not, you know, and it's not just upsetting the environment, it's the fear that's instilled in you. And so, you know, he was violent on other occasions aside from those events, and buried back in my mind was, I better say nothing or I'm going to be killed, quite honestly.
And then in a surreal development to this, your brother, because an officer happened to be walking by a car, was abusing a teenage boy. And he was apprehended, etc. And you came forward and said, I can speak to this abuse at the hands of this person. He did it to me. But Elizabeth, how that was or was not allowed to be evidence introduced at court, and you spent a lifetime in this field, surprised me. Obviously it didn't surprise you. Statute of limitations, you would think for something like that, this would be a mitigating factor. This would be evidence that a court would want to know, but apparently not.
Well, one of the other things that we did as prosecutors was we could introduce something called Molyneux evidence, which was if a defendant had a particular scheme or a way that they did things with multiple victims, that we would make an application to the court to allow us to introduce a pattern of behavior that was specific to that particular offender. So I don't know if that was something that was tried in the case against your brother, Tom, but that was something that we would often do, because in many of these cases it was not a one-off. You know, they were not outliers, these were predators. And I think what the public has seen through movies like Spotlight, many of these men don't come forward until much later in their lives. And as we were discussing earlier, it's almost as if something happens inside them where it can no longer be squelched and it begins to erupt. They do have a lot of depression, suicidal ideation, a lot of addiction issues. So their lives begin to crumble.
And let's do some of the math here. First of all, I was shocked that the most common age where a youth is abused will be at the hands of a 14-year-old boy.
Yes.
For a male victim here. So how long under current law, and New York is among the harshest in terms of how the statute of limitations applied, how long does a victim have to come forward? And then we'll get into what the proposal is before Albany.
Yeah, I mean, right now, it's, age of 23, it's pretty much 5 years after your 18th birthday or when the abuse occurred. So it is really very confining. And, when I was 11, it took me 14 years, so already that was passed. But even when I first mentioned it to my wife at Bryce Canyon and then, was thinking about jumping shortly thereafter, I bottled it right back up, and it took me another 4 years just to get to therapy. And so even when I first started therapy at 18 years after the age of 11, I wasn't ready then either. So it's really way too short of a time, the age of 23. You need to do much better.
And talk about the proposal right now, and I've seen polling more than 90% agrees in terms of not making 23 the cutoff.
The governor supports it.
Right. I mean, I'll get to the politics in a second, but what would we like to see for criminal and civil the ages expanded to in terms of, statute of limitations?
Well, I think there have been proposals to do 50 years on the civil side,
yep.
And there are varying proposals on the criminal side as well. I'd like to see something. I think there's an average age of 42 when a survivor comes forward. So, we should be taking that into account. What are the ages that survivors typically feel most comfortable coming forward?
We have to meet them where they are. We have to provide the resources and the services for what they need. One person may need to file a lawsuit because that's how they're going to heal. Somebody else may feel that they don't need to do that. So it's just in the panoply of options that we need to offer victims.
Elizabeth, thank you. And Tom, I got to tell you, whether it's in the prior conversations or the audience hearing us now, I guarantee you've helped people along the way here by having the courage to come forward. And I thank you also for coming with us.
Thank you very much.
I agree. Thanks for having us.
Coming up next, our civil rights attorney, Mayo Bartlett. He will join us to talk about a couple of cases in the news. Rapper Meek Mill, well, he's out of jail. Now his supporters are saying his case highlights when it comes to racial inequities in the criminal justice system. Plus, the African-American man arrested in Starbucks, they've lawyered up. We're going to take a look at what they could sue for and what they could get.